This is Bloomberg Law with June Grasso from Bloomberg Radio.
After a trial that lasted almost 2 months, exiled Chinese tycoon Guo Wengui was convicted of a massive fraud and duping investors out of $1 billion to fund his lavish lifestyle. Guo's criticism of the Communist Party won him legions of online followers, and prosecutors say he fleeced those loyal followers out of their money for seemingly legitimate businesses and then diverted the funds to himself so he could spend his days living in his $26 million mansion, lounging on his $37 million yacht, driving his $1 million red Lamborghini. Not to mention a $4 million Ferrari for his son, a more than $1 million jewelry box, and other extravagant purchases. Joining me is Bloomberg legal reporter Ava Benny-Morrison, who covered the trial. Ava, the jury convicted him of fraud and racketeering, 9 counts out of 12. Tell us about the prosecution's case.
Miles Guo was charged with 12 different offences related to a scheme to defraud investors out of $1 billion. Prosecutors alleged that he did this in a number of smaller schemes, one related to a cryptocurrency exchange, another related to a farm-to-loans program, and an exclusive membership club called G Clubs. The allegation was that he really pried on his followers that he had amassed through his anti-Chinese Communist Party campaign. A lot of people online gravitated towards his online videos and his very outspoken critical statements against the Chinese government. And then he appealed to them to invest money in these various business opportunities. The prosecution said that he took a lot of this money, more than $1 billion, and spent it on himself and his family.
He had incredible wealth that he flaunted, and the prosecution spent some time on showing how he spent his money.
Yes, the prosecution said that he spent a lot of investor funds on enriching himself and his family. So that included a $26 million mansion in New Jersey, a red Lamborghini, a Ferrari for his son, a $60,000 TV, ridiculously expensive mattresses, all of those luxuries that went into living a very opulent lifestyle. The defence came back and said, look, he is used to this lifestyle. He came from a really wealthy family of property developers in China, and while most people might think it's outrageous to spend $35,000 on a mattress, these were things that Miles Guo was used to, his lawyers argued, and he shouldn't be judged for that.
His crusade against the Communist Party, what part did that play in the trial?
It was a big argument that the defence put forward. They tried to paint him as someone who had devoted his life to the whistleblower movement and put himself in grave danger because of that. They said that he was an unapologetic critic of the Chinese government and fled persecution in China to the US, where he sought political asylum in 2017. And the defence said that he had been the target of retaliation by the Chinese government. They'd tried to extradite him back to China a few years ago. They'd hacked into his bank account, his phones, his laptop. They said that he had put himself at great risk and painted him as sort of this brave political crusader and an activist. The government essentially suggested that this was all a bit of a front, and even if he was a political activist, it didn't have anything to do with the crux of the case, which was that he defrauded a lot of investors out of a lot of money.
A 2-month trial. Start with the prosecution. What kinds of witnesses, which were the most effective?
The most effective witnesses were some of the investors themselves that the prosecution called. They described investing money in some of Miles Guo's businesses and his companies like GTV Media, which was a social media platform, and G Clubs, the exclusive members-only club, the farm-to-loan program, and a crypto exchange. They said that they gravitated towards Miles Guo's videos, where he was critical of the Chinese government. Some of those videos he recorded in the penthouse at the famous Sherry Netherland Hotel that overlooks Central Park in Manhattan, or on the deck of his 152-foot super yacht, which was often moored off the coast of Connecticut, where he had another house. So some of these investors spoke about how they admired him and they believed in what he was saying and were on the same page as he was when it came to speaking out against the Chinese government. So they felt comfortable in investing their money with him, but then they never got it back. And I remember one witness being on the stand who would get quite emotional at times, was saying, just because you're anti-CCP doesn't give you an excuse to rip people off. It doesn't give you an excuse to commit fraud either. So they were some of the most powerful, I think, prosecution witnesses. We also heard from luxury car dealers who sold Miles Guo or his companies these extremely expensive and rare cars as well. One of the other witnesses was a managing director at a hedge fund run by Kyle Bass. Miles Guo had transferred $100 million, which the prosecution said was stolen from investors, to one of Kyle Bass's hedge funds. Interestingly, he was actually acquitted of 3 charges, and those 3 charges relate to the stock offering in GTV, the social media platform company, and the $100 million transfer to the hedge fund. On the defence side, Miles Guo didn't get on the witness stand himself, but the witnesses that they called all sort of spoke to Miles Guo's position as a political activist and why he felt so strongly about speaking out against the CCP.
That being the Chinese Communist Party. And he was friends with Trump advisor Steve Bannon, who got $1 million payment from one of Guo's companies and was arrested on Guo's yacht. Now, the prosecution played for the jury a secretly recorded phone call between Guo and his subordinates in 2021. What did that show?
Yes, the prosecution in its closing address to the jury opened with this quite dramatic phone call recording. Before the prosecutor even started speaking, he just pressed the play button and this recording played out across the courtroom, and you could hear Miles Guo yelling at some of his employees. He was speaking with some of his staff, and the discussion was around the transfer of money from one of Miles Guo's entities to somewhere else. And one of Miles Guo's employees was saying, like, hang on, we need to go to the board with this. And then all of a sudden you can hear Miles Guo, who was speaking in Mandarin, but the translation was included in subtitles before the jury. He's yelling at his employee, calling them a scumbag, telling them to go to hell, telling them to shut the hell up. So it was quite dramatic. And what the prosecution was trying to do there was say to the jury, Miles Guo might sound very reasonable and softly spoken and almost, at times demure and calm in his videos that many of his followers and investors have seen. But, behind the scenes, he could be quite brash and abusive to his employees.
His supporters were in the courtroom every day. A lot of his supporters?
Yes, every single day the court was packed with his supporters. There must have been anywhere between 30 and 40 people every single day, without a doubt. They would file in there. Some of them were wearing T-shirts or jackets or scarves with the G Fashion logo on it, and G Fashion was another one of Miles Guo's companies. So you could tell that they were very, very supportive of him. Every time he would walk into the courtroom, they would all sort of wave and smile at him. And at different points throughout the trial days, he would turn around, he would look at the public gallery and give everyone a smile. It was quite amazing to see them turn up every single day over the course of almost 2 months. Towards the end of the trial, there were also some detractors. So there was a little bit of tension in the courtroom, and you could see towards the end there were more US Marshals turning up to make sure everyone was sort of behaving themselves. And the court security officers were, making sure that they were talking to these people and telling them to be respectful of the environment that they were in. Once the verdict was handed down, we were expecting some sort of emotions and tensions to boil over, but everyone was very calm. Even Miles Guo himself was very calm. If anything, he was comforting his lawyers who fought very hard for him and put up a pretty good case throughout his trial. He hugged one of his defence lawyers. He was shaking the hands of the others before he was led away. Once all his supporters got outside the courthouse, there was a little bit of yelling and back and forth outside the court building, and some of the US Marshals had to step in and tell them just to calm down. So, yeah, it was quite impressive to see the people that turned out to support him every single day.
And something very unusual here. The judge kept the names of the jurors secret. What was the reason for that?
That's right. Before the trial began, there were arguments on both sides as to why there should be an anonymous jury, and this is quite an unusual step. The prosecution had argued that the jurors were potentially at risk if they were identified because of the very strong and loyal supporter base that Miles Guo had, and they were a bit worried about maybe retaliation, whereas the defence had argued that, yes, the jury should be made anonymous, but the risk was coming from the CCP. So the judge didn't rule either way, but she said that, yes, essentially because this case has attracted so much intense interest, that the jury should remain anonymous, and they were escorted by US Marshals to the court each day.
And they deliberated over 4 days, but they had to start again?
Yes, they started and then were a few hours in before one of the jurors let it slip in deliberations that they had Googled the name of the co-defendant, a man called Guo Wengui, who is actually still at large. He was a financial advisor to Miles Guo and featured prominently throughout the trial. And then the jury foreperson wrote a letter to the judge saying, we've got a problem here. Now, this is sort of Jury Service 101. You're not to read any external news articles about the case that you're serving on the jury of. You're not to Google certainly anyone that's mentioned in the case or do your own research. So everyone sort of held their breath when the judge read out that letter and, we were worried, is this going to be a mistrial? But fortunately, they were able to just excuse that juror that did the Googling and bring in an alternate, and they started deliberations again. So that jury deliberated for about 3 days until they came to a verdict.
You always have to have those alternates ready. So he's going to be sentenced on November 19th. How much time does he face?
Even though he was acquitted on 3 out of the 12 counts, he still faces decades in jail. For the most serious charges, the fraud charges, the racketeering conspiracy, he faces up to 20 years each on those counts. So he's definitely facing a long period in prison. And because he is a Chinese citizen, he faces extradition back to China as well. And there is a Interpol red notice out for him issued by the Chinese government. So his troubles will, I think, continue once he's released from prison.
And he's already been in prison for more than a year now. Thanks so much, Ava. That's Bloomberg legal reporter Ava Benny-Morrison. Coming up, the ramifications of the Supreme Court's decision on homelessness. This is Bloomberg. For the first time in 4 decades, this term the Supreme Court ruled on homelessness, and the ramifications of that decision are already being felt across the country. In a decision split down ideological lines, the court's conservative majority reinstated an Oregon city's law banning homeless residents from sleeping outside in public places. Now cities across the country are weighing their policies, and some are preparing to take a harder line on homeless encampments. Joining me is Sunita Patel, a professor at UCLA Law School and the founding director of the UCLA Law Veterans Legal Clinic. She co-authored an amicus brief in the case with the National Coalition for Homeless Veterans that was quoted by Justice Sonia Sotomayor in her dissent. What was at stake in the Grants Pass case?
The Supreme Court was deciding whether or not to allow punishment for homeless people with no access to shelter who are sleeping outside with as little as a blanket or a balled-up shirt for a pillow. And what was behind all of this was a prior Ninth Circuit decision called Boise versus Martin, where the Ninth Circuit had said, okay, cities and states can use restrictions on when, how, and where unhoused folks can sleep outside, but they can't criminalize activities like sleeping outside or eating outside, as Justice Brown pointed out, if there is no alternative reasonable place to sleep. So when you had no adequate shelter space, there was a lot of hand-wringing by the cities and the states saying that they weren't able to enforce the laws well enough. And what we see with the Grants Pass decision is that the court kind of buys into the unnecessary hand-wringing from the cities and states that weighed in, because they were complaining that the Ninth Circuit's prior decision in Martin tied their hands from enforcing anti-camping laws.
And so why did the court come to the conclusion that this wasn't cruel and unusual punishment?
The court was really looking at whether or not these ordinances from Grants Pass, Oregon, criminalized and punished homeless people for the status of being homeless, or whether it was for actions associated with being homeless. And so you see this interesting play in the majority and the dissent, where the majority says, well, this is a punishment not of status, but of actions that people are doing. This is not actually a case that falls squarely within the prior precedent called Robinson, which had been in place for 50 years already. And the court decided that the punishments here were not actually cruel, that they were not severe enough. So that's what they decided.
And Justice Sonia Sotomayor's dissent had some emotional overtones in describing the crisis of homelessness.
Well, I think that for many people in this country, the idea of living on the streets is quite a stark reality, especially if you've lived on the West Coast or she's from New York City in the Bronx. You see the plight of unhoused folks on a daily basis. And in those circumstances, we're left to think, well, how can it not be cruel to require someone to sleep on the streets without even a blanket in the cold winter of Grants Pass and have nowhere else to go? So here, I thought she actually did a very careful analysis of the purpose, the text, and the enforcement of the Grants Pass ordinances. I agreed with how she showed the ordinances actually criminalize status, right? So the action of sleeping outside is something that necessarily defines the status of being unhoused. And it is a human biological need. Another thing that she points out, which is what the Ninth Circuit pointed to as well, is that the Martin decision left open lots of ways to regulate homelessness. So you're still able to fine or ticket someone because you don't like where they're sleeping. You're still able to fine or ticket someone if they are intoxicated in a public area, if they urinate in a public area, if they're obstructing an entryway or panhandling. There's a host of petty offenses that you can still enforce. It was really just this idea of sleeping outside at night with a small covering, which literally defines being unhoused, that was in front of the court. What they decided was that in order to apply the Eighth Amendment cruel and unusual punishment clause, it would need to extend the prior Robinson ruling, sort of extend it slightly around a status offense. And luckily, they said Robinson is still the law of the land right now, which is good. It's been a precedent that's been around for decades. And when the court upsets precedent, it can turn things on its head.
And we've seen that a lot in the last few terms. In Grants Pass, were they actually arresting people who were sleeping outside at night?
Yes, that's my understanding. The two plaintiffs in this case, they were cited for and fined and eventually excluded from the city, but they were sleeping in cars. The definition of camping in the Grants Pass ordinance includes sleeping in any vehicle.
How do you think this decision will affect homeless veterans?
Yes, that's a very good question. So the UCLA Veterans Legal Clinic worked on behalf of the Coalition for Homeless Veterans, and we filed an amicus brief in the case that Justice Sotomayor did cite briefly. And we really presented the picture of what it's like to be an unhoused veteran, the complications that come with acquiring work or receiving your medications or finding your social worker when you sleep outside and you're being shuffled around because of criminalization efforts, because of police enforcement. And so this decision is going to affect veterans in the same way it's going to affect other unhoused populations, unhoused communities. We will see the veterans that we represent, the veterans around the country, getting moved around, unable to locate and connect with their service providers, lose their medications, lose their paperwork. All of these things make it extremely difficult for them to obtain permanent housing, even in a resource-rich system like the VA, where there are lots of options and different ways for individuals to become housed and get connected to housing.
And Justice Sotomayor, in quoting from your brief in her dissent, talked about Erin Spencer, a disabled Marine Corps veteran. Tell us what she said.
She's discussing how diverse the veteran community is and how this decision is unfortunately going to affect marginalized and vulnerable populations more. We know that, for example, 37% of the homeless community is Black. even though they're 13% of the general population. And because of structural racism, lack of access to housing and jobs, we have this racial disparity. When it comes to veterans, we also have a pretty stark disparity for unsheltered veterans in comparison to the veteran population, the general population. And so here she's pointing out that veterans are more likely to become homeless if they have served in combat, if they have PTSD. And she talks about the case of Aaron Spencer, who is a disabled Marine Corps veteran, and he was putting his tools and his bike parts and other things that he uses to make money on the side in a cart. And then he was arrested repeatedly for illegal lodging, for being on the streets. And every time his cart and his belongings, they were taken away. And, she quotes him saying, "The massive number of times the city or state has taken all I possess leaves me in a vacuous deja vu." And this is really sort of indicative of the stories that we hear from unhoused veterans and unhoused people in general. There's this sense of, I don't know when I wake up, am I going to be able to sleep here or not? Are my things going to be taken? Am I going to be facing some bureaucratic nightmare today as I try to access services and food and shelter and just the basic human needs?
How does this opinion leave you feeling as an advocate for homeless veterans rather than as a lawyer?
I am doing a research project on homelessness in LA County. And, I think this idea of the cycle of moving in and out, the majority opinion sort of suggests that, well, police are really on the front lines of protecting our unhoused folks and getting them into services. I mean, it's just not the lived reality of the people we speak to. And that is really a problem, I think, when the Supreme Court doesn't recognize the wealth of research, social science, and other research that's out there, but instead is quoting from the Sheriff's Association briefs on the work that they do to help connect veterans. That's one thing that is a bit of a problem. But I'm hopeful that there are other ways for us to challenge these laws. I mean, as an advocate, we always say, well, the fight's going to continue, right? So the court left open lots of other ways to challenge really problematic laws. We have the due process clause. There's several claims there. There's also in Grants Pass, there is a provision on the fines and fees clause, excessive punishment clause, that is still a live challenge that's in front of the district court. The city didn't appeal the loss that they faced on that claim because they really couldn't. I mean, the punishment that they're seeking against someone for sleeping outside is so excessive and beyond the pale that they would have lost, clearly. And so they didn't even challenge that. So advocates can raise those claims. Advocates can also raise other claims like vagueness challenges. There are some other ways to continue the sort of legal challenges. Now, that's me being an optimist. The reality is that I think that this is just going to clear the groundwork for more police actions, more coercive activity, and ultimately that is not going to actually solve the problem and the crisis of homelessness that we're facing today. There are proven solutions. Obviously, we need more affordable housing. We need more access to the resources that will help people not only become housed, but stay housed, because there's a problematic kind of cyclical effect. If you stay homeless, if you have these tickets, they affect your credit. And then when your credit is bad, you can't find a house. I mean, this is all very connected. And so, unfortunately, we had the LAPD already has tweeted that, now we can do what we want sort of thing. And I think that, unfortunately, that's going to be the law enforcement mentality rather than, helping, I should say, hopefully cities and counties around the country will not take the bait. They will actually decide that they're going to decline to over-enforce these laws and put excessive fines through the court system, which will only make it more difficult for people to move out of living on the street.
Are there any cities that are dealing with the homelessness crisis successfully?
Remarkably, I would say yes. I mean, Houston has made a lot of progress in solving homelessness by funding housing and services. Also, Miami-Dade County has done a pretty good job, and Milwaukee has also had a remarkable 90% decrease in unsheltered population.
So some hope there. Thanks so much, Sunita. That's Professor Sunita Patel of UCLA Law School. Coming up next on the Bloomberg Law Show, it's time for the Summer Olympics, and there are lots of rules for companies who are not sponsors. I'm June Grasso, and you're listening to Bloomberg. The Summer Olympics is coming up, and like everything else at the Olympics, there are lots of rules and regulations around the exclusive rights of the International Olympic Committee and the U.S. Olympic Committee to everything from symbols like those famous interlocking rings to terms like Team USA. The IOC and USOC are hyper-vigilant, so companies have to be very careful or they could get a cease and desist letter or worse yet, be sued. Joining me is an expert in trademarks, Fara Sunderji, a partner at Dorsey Whitney. Tell us about the exclusive rights of the IOC and the USOC.
Sure. So the trademark situation with respect to the Olympics in the United States is very interesting, and it's a little bit different than your average brand. While the USOC does have regular trademark registrations, they also have statutory protection in the form of the Ted Stevens Olympic and Amateur Sports Act, which was originally passed in 1978, and then it was amended again 10 years later. So the reason for all of this is actually pretty interesting. The United States is one of the few countries where the Olympic teams are not funded by the government. The funding actually comes solely from sponsorship. And so in order to keep those sponsorship dollars really rolling in from large sponsors, they have to make promises to the sponsors or the would-be sponsors and say, hey, brands, you guys are paying a lot of money to sponsor the team. We're going to make sure that other brands who are not paying those sponsorship dollars don't step on your exclusive rights. And so that's basically the genesis of the statutory protection. There was actually a Supreme Court case in 1987 where the San Francisco Arts and Athletics Association, they wanted to use gay Olympic Games. And the case went all the way up to the Supreme Court, and the Supreme Court confirmed that they could not use it. The statutory rights that are involved here don't violate the First Amendment. And an interesting piece that also came out of that case was actually that the USOC, when they sue somebody for trademark infringement, unlike regular brands who own trademark registrations, they do not have to prove likelihood of confusion. It's almost a strict liability circumstance where you use the trademark Olympics, you use Go for the Gold or Let the Games Begin in any kind of advertising here in the United States, and it's automatically deemed trademark infringement, and then they take it from there. So it's really sort of a step above regular brands.
So now let's go through the basic list of do not use, starting with the Olympic rings logo.
So the protection here extends to the Olympic ring logo. It extends to the word Olympics, Paralympics, Team USA, Go for the Gold, Let the Games Begin, Paris 2024. And the list is a little bit longer, but those are sort of the main ones. There is an interesting carve-out that happened, I believe, when the statutory section got amended, where companies who are validly using the term Olympic in association with the Olympic Mountains in Washington are allowed to do that. But everybody else is not going to be able to use it.
And what about images of the athletes or, snippets from the games?
The other things that you can't use when you're doing marketing during the Olympics or frankly ever is if you're not affiliated and you don't have a license, you can't, say, put up a social media post and use an image of, an athlete participating at the Olympics. It violates the right of publicity of the particular athlete who's in the picture, and it also violates the copyright that's probably owned by, the International Olympic Committee or the broadcaster who took the video or the picture.
One of the biggest concerns is what's referred to as ambush marketing. Tell us what that is.
Sure. Ambush marketing is, it's actually kind of an interesting way to market. And it's not your sort of typical, we're going to put an ad up or, talking about our brand or our company, or we're going to put an ad on social media. Ambush marketing is something that's a little bit dicey, and it is actually prohibited by the Ted Stevens Act. And the International Olympic Committee, wherever the games are, they've got pretty strong rules against it. One of the sort of interesting examples of ambush marketing happened in the 2010 World Cup. Budweiser was actually the official sponsor for beer, and this Dutch beer brand, Bavaria, they purchased a bunch of tickets to one of the matches, and they gave them to a bunch of women and asked all these women to wear bright orange mini dresses. And so when you looked at the crowd, your eyes were instantly drawn to the sort of orange section. And, that's a good example of ambush marketing. And after the game, I believe the games were in South Africa that year, the women were actually detained and the beer brand was charged. Again, they pay, the official sponsor pays a lot of money, millions and millions of dollars in many cases to sponsor and have all the ads and stuff like that during the games. And a brand like this bought a handful of tickets and they got a bunch of publicity. And, the World Cup, FIFA, the NFL does not obviously permit that or like that, and the Olympics don't like it either.
How aggressive is the IOC and the USOC in protecting their rights?
The Olympics is very aggressive. In the United States, the USOC, which is the U.S. Olympic Committee, they have an army of lawyers, whether they have outside lawyers or inside lawyers working on this. In the period around the games, they send out so many cease and desist letters each time there are games. They also provide guidance beforehand for marketers trying to, avoid mishaps during the games. But I think their team is probably online and working, 24 hours a day during the games to try to ensure that nobody who's not a sponsor is really working with and, capitalizing on the goodwill of the Olympics trademarks.
And is it just big companies they go after, or do they go after small companies, everyone?
In the past, they've gone after everyone. They have gone after, I believe there was a case, now it's probably many years ago, where they went after a small carpet company in Minnesota for using Olympics in their name. So I think they go after big companies and small companies. Probably now, after so many years of really large enforcement, I think that major brands are well aware of the situation and are not going to step on the toes of the Olympics rights. It's probably more smaller brands these days. And with social media, it's so easy to step on the toes here because the USOC doesn't want you using, hashtag Team USA, hashtag Olympics. They think that is there, and they're right in the United States per the statute that those are their trademarks, and they don't want them being used without payment.
Do they go after individuals who might do that on social media?
So they don't go after individuals. I think there's sort of four buckets here, right? There is the companies who pay to be sponsors of the Olympics and pay a large amount of money to be sponsored of the Olympics. Then there's another group of companies and brands that sponsor individual athletes. They don't sponsor the games themselves, but they sponsor individual athletes. Then there are companies and brands that don't pay any sponsorship fees and are just out there trying to capitalize on interesting marketing situations, which really comprises a large group of companies, right? And then there are individuals. Individuals have a lot more rights for fair use because they are not using these trademarks in commercial manners. If I want to go on my Instagram account and just write a post saying, I love the Olympics, I think it's awesome, hashtag Team USA, the likelihood that the USOC is going to come after me, I think is pretty small. Also, considering I don't really have that many followers, it's not really making any impact on anything. But companies who do it, it's a different story because it's a commercial use on social media or, in another forum. The middle sort of group of brands who sponsor athletes but don't sponsor the games officially, in recent years or recent Olympics, the IOC and the USOC has created many, many rules for those types of brands about when they can congratulate their athletes, how they can congratulate their athletes, how often they can post during what they call the blackout period. And it's a very complex set of rules about what they can do and how they can do it, what imagery they can use. Like I said, it's very complex, but they do provide pretty good guidance on it.
Can AI be used in any way to get around these?
AI is obviously the hot topic of the year. I guess it was clearly hot before that. But AI in marketing can be fantastic. It can also be really dangerous legally. And using AI to, for example, clone a voice, that's not going to get you around a right of publicity claim. It's not going to get you around any kind of copyright claims or anything like that. You still have to be mindful of the basic IP rights of different rights holders. And just because you're using AI doesn't mean that you can step back and say, oh, we didn't create this. It's not us. And just because it's technically possible, for example, to clone someone's voice, doesn't mean you have their permission and you could still get sued.
Any closing thoughts?
For marketers who fall in the last bucket, where they don't sponsor the games and they don't sponsor a particular athlete, there's still opportunities to be involved in marketing during the Olympics. You just have to be very careful, obviously. You can't use the trademarks, as we said. You can't use footage and you can't use images of athletes. But that doesn't mean that your team can't be watching the Olympics and, moving dynamically and creating really great ads about, what has happened. I think one of the best examples, sort of real-time marketing, happened it's actually one of my favorites, in the 2013 Super Bowl, when the lights went out in the middle of that Super Bowl. There's this very well-known now in marketing circles tweet that went out from Oreos. They wrote a post that said something like, "Power out, you can still dunk in the dark." They didn't mention Super Bowl. They didn't even mention big game. But the tweet, it went out like wildfire, and everybody picked it up during the game and thought it was this great marketing sensation, and they got so many impressions from it. And they didn't step on anybody's IP rights. It was a really great piece of marketing. There's another one specifically from the Olympics that I always like to cite to as a good example. Nike has an ad where they have a picture of a boy standing on one of those platforms above a very large pool that you often see, in the diving competition in the Olympics. And it's a small boy, and we just see his back. And it says, "Find your greatness." It's not using anybody else's IP. You're not having an image of a famous diver on the platform. There's no flags. There's no Olympic trademarks. But you get the look and the feel and the spirit of the Olympics in there. And I think it's such a great ad.
Some great examples. Thanks so much, Farah. That's Fara Sunderji of Dorsey Whitney. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.